Welcome back, everybody. The Supreme Court refusing to hear the case of a same-sex couple who wants both their names listed on a birth certificate for their newly adopted son. The New York couple adopted their son, who was born in Louisiana back in 2006. They requested a new birth certificate so the child could be put on one of the men's health insurance plans. But the Louisiana registrar said only a married couple could jointly adopt in Louisiana. They instead offered to place just one of the men's names on the birth certificate. I'm joined now by Oren Adar. He's part of the same-sex couple who adopted that child. Oren, it's nice to have you on with us this afternoon, and let's get straight to it because the Louisiana registrar says this is simply an issue over you and your partner not being married at the time of the adoption, but you were not denied legal recognition of the adoption in New York. So why do you feel that you and your partner are being treated unfairly in this instance?
Well, if you ask the state of Louisiana, they're basically saying because we're an unmarried couple. Well, that seems to be the catch-22, is that we can't get married, and even if we did get married, Louisiana would not recognize that marriage. Really, the issue here that we feel is that this is more of a constitutional issue. This was an adoption that happened in the state of New York. The decree was sent to the state of Louisiana, and because of full faith and credit, they really should have granted us the amended birth certificate, just like in any adoption.
Have you thought about coming back to New York and getting married here and then going back to Louisiana to say, because it is legal to get married in New York with marriage equality, to go back to Louisiana, would they recognize it then?
They still wouldn't recognize it, and it's just as a matter of a point. My partner and I did actually have a civil union in Connecticut, because that's where we were living at the time, just over the border. And that civil union has become, just as a matter of law, is now considered a marriage. So technically we are married. Louisiana does not recognize it.
Oren, Louisiana Attorney General's, the Louisiana Attorney General said that he was pleased with this decision by the Supreme Court, saying that it does not compel, or he does not compel, Louisiana to change its public records to conform to other states' laws. When you hear something like that, what's your response to that statement?
Well, I mean, it's disheartening, and it makes us very, very angry. Really, at the crux of the matter is our child's rights. This is not a gay rights issue. This is a children's rights issue. This makes our son really a second-class citizen. He doesn't have a birth certificate, and we don't understand that. That's the part that's confusing to us, and it's very upsetting.
Where do you go from here, and how do you make sure that your son is properly medically covered through insurance? Well,
we've had to do some things. We've had to supply documentation. We've had to supply really the adoption decree from the judge, which is a sealed document. So technically we're breaking the law. Each time we use that document to establish our child-parent relationship, we're being asked to break the law, and that's what we've had to do, and we do that for our own protection. So at this point, from my understanding, really it's legislative action, and it's going to take some time, and it's going to be difficult, but we're not giving up. I mean, we're doing what's right for our child, and honestly, for many children that are out there, we've been in contact with other families that have had the exact same issue.
Oren Adar, we wish you the best of luck as you continue this fight for your child and your family. Thanks for coming on and sharing your story with us today.
Thank you for having me.